As an attorney who's helped protect thousands of real estate investors, I see the same mistake being made over and over. Choosing the wrong LLC structure to own that real estate. Today, I'm going to get into the details and tell you the truth about using Wyoming LLCs for your real estate. What the marketing hype is getting wrong, what snake oil, what actually works in the courts, and most importantly, how you can protect your real estate if there's litigation across multiple states. Whether you own one property or you got multiple properties and you're building an empire, this video is right for you so you understand the strategies that actually work and that investors use to scale. Let's get into the details. Getting started. This is where the snake oil comes in, right? What are the common misconceptions that people have? People think that if they form a Wyoming LLC and it owns real estate in another state, they're protected. They're going to be protected by Wyoming's LLC laws when it comes to veil piercing. Maybe they're not suable in their home state. That is not correct, okay? If that LLC is owning real estate in a particular state and it's renting to the public, it's doing business in that state. It's got nexus to that state. It's subject to the laws of that state. It could be sued in that state. You may actually get yourself in more trouble by having an out-of-state LLC owning that real estate because it's not authorized to do business in that state. It has not either registered as a foreign entity in that state. It's not been authorized to do business there, foreign qualification. So you can't use a Wyoming LLC without more to own real estate in other states. That applies everywhere. You can't use a Florida LLC to own real estate in New York or a Wyoming LLC to own that real estate outside of Wyoming. That doesn't mean a Wyoming LLC doesn't provide benefits in your LLC structure, but it's not going to be the direct owner of the real estate. A Wyoming LLC works as a holding company for real estate. You form a Wyoming LLC not to own the real estate, but to own another LLC that does own the real estate. So you form an LLC in Wyoming, then form a subsidiary LLC in whatever state the property is located. That LLC then takes title to the property. This provides a dual benefit. It provides a benefit of enhanced veil piercing protection. Some states' laws are not fantastic when it comes to veil piercing. It may be easier to pierce the veil in Florida than it is in, say, Wyoming, which has some of the strongest veil piercing protections in the country. So if you have a Florida LLC that owns a real estate and they attempt to pierce the veil on that real estate and get to its owner, it's not you. You are not the owner of the Florida LLC. You're the owner of the Wyoming LLC, which owns the Florida LLC. So now you got a double layer of protection. If they want to pierce the veil, they need to win twice on that claim. The other thing it does for you is charging order protection. Wyoming, hands down, has the strongest charging order protection in the country. What is charging order protection? If the member of an LLC has a judgment against them, that creditor, the creditor of the member, it's not an LLC creditor, the creditor of the member cannot break into the LLC and take its assets. They cannot foreclose on their membership interest. They have to sit on the outside of the LLC and wait for something to happen, which the good news is you probably wouldn't let something happen. So you now have your personal creditors or your partner's personal creditors can't disrupt the LLC's business, either at the Wyoming level or the subsidiary company level. Two huge benefits of having a Wyoming LLC. There's, of course, others, but for real estate, those are very important. The physical property location is what's going to drive the formation of those subsidiaries. See it all the time. People, I don't know why, they form their Wyoming LLC, they have it take title to property in Florida, and they think somehow that's going to shield them from liability. It does not. They get sued in Florida courts. The court has jurisdiction over the Wyoming LLC now. The Florida court is going to apply most likely Florida LLC law when it comes to veil piercing, and they haven't gotten the benefit from it. The other thing I see people do is they say, well, I'll foreign entity register my Wyoming LLC in Florida, okay? That doesn't help either. You still only have a single layer of protection, and you've subjected that Wyoming LLC to Florida law. very unlikely that the Florida judge is going to look into Wyoming law and say, oh, we can't pierce the veil under Wyoming law. They're going to apply most likely Florida law in that case. So foreign entity registering doesn't even save you money, right? Because the cost to foreign entity register or foreign qualify a company in a state is typically the same price as forming a company there. So by having a holding company and subsidiary, yes, we've got two companies, we've got two sets of fees. But if you take your Wyoming company and register in Florida, you have two sets of fees anyway. Before we continue, if you're getting something out of this video so far, I really want to encourage you to tune in to my webinar on February 4th. We're going to do deep dive on real estate, on some of the complexities that you're going to run into as you're setting up a Wyoming holding company structure and managing your multi-unit portfolio. February 4th, see below for more information about how to tune in to that webinar. So the basic protection principles here are that we want to talk about with the LLCs is, number one, have a Wyoming holding company. Number two, form the LLC that's going to own the real estate in the state where the property is located, where it's doing business. And number three is going to be, you probably don't want to mix multiple properties into a single LLC. This is not a hard and fast rule. What I like to apply is a risk versus equity analysis. And if we say it's a high risk property, even though you might not have a lot of equity in it, you probably want to have it in its own LLC. And a high risk property would be like Section 8 properties. Love renting to Section 8 tenants, but there tends to be sort of more problems with Section 8 tenants. The other thing, if it's commercial property, you got a lot of people coming in, there's a lot of opportunity for things to go wrong, then that would likely be in its own LLC. Now, if you've got condos in the same building, right? Same building, same HOA, the condos maybe you've only got $25,000 or $50,000 of equity in them. Those, I think, are okay to put multiple in a single LLC. Keep your administrative cost and burden down. You may have one cleaner who's going to all of the properties or something like that. So you'll save, or prevent something like you're sharing expenses across them. So those are the basics here. Now let's get into local versus Wyoming LLC. And here's why it actually matters, okay? If a business, whether it's out of state or in state, if it's doing business in that state, it has a nexus there and can be hauled into court in that state. You're not preventing someone from taking action against your Wyoming LLC if it's owning real estate in Florida. They can sue you in a Florida court, and they're going to be able to. There is jurisdiction over that LLC. They will have to send a service a process. They're going to have to serve the company up in Wyoming. It makes it a little bit more challenging for them. But the problem, if you haven't foreign qualified the company, if it's just a Wyoming LLC, is that you give up certain rights if you're not foreign qualified, or you don't gain certain rights. One of them is typically the ability to sue in that state. So your company can't initiate the litigation in a Florida court. Your Wyoming company can't. And in many cases, you can't countersue if there's contributory negligence or something else where you'd like to sue the party who's suing your LLC. You may be prevented from doing it. There could be penalties involved for not registering there, as there are in California. There's definitely penalties if you should be registered there and you're not. So that foreign qualification, if you are going that route, I don't recommend it. I recommend the holding company and subsidiary company structure. Just remember, it's not going to protect you whether you do it or not. You're better off doing it. If you don't do it, you're really not giving yourself any benefit. Comparing those costs again, if we think about the cost to form Wyoming LLC and then form subsidiary company LLC versus the cost to form Wyoming LLC and foreign qualify or foreign entity register in that state, in all the cases I've seen, there may be some outlier here, it's the same. X dollars, Y dollars, whether you're doing the registration or you're doing the foreign entity registration or you're doing the additional company there, costs tend to be the same. The administrative burden, I'm going to say a slight difference in administrative burden if you have a holding company and a subsidiary. The administrative burden is that, well, you do have to maintain, the companies in compliance in both states. You would still have to do that with foreign entity registration. You'd have to have registered agent in both states. You still need to do that with foreign qualification. Where you would have a lesser administrative burden is you would only have one EIN, because the single company in Wyoming that's registered in, say, Florida would have one EIN. You could have one bank account. But if you have two companies, you need two EINs and two bank accounts. And then you need to manage and make records of the transfers between the two companies. Keep a little bit more to do in terms of the administrative burden and record keeping and in your banking relationship. But the reality is, banking relationship between the two companies, the reality is the holding company doesn't do a heck of a lot. It's not a mere shell. It's not just a shadow entity, but all of the activity is happening at the subsidiary company level. Rents come in, expenses go out, you're managing the property, doing all that through the subsidiary. The net amount after reasonable working capital reserves gets moved to the holding company. And the holding company, it doesn't have many expenses. It's got maybe it's administrative fees, maybe there's some accounting or something like that, but not much going on at that level. So there is a slight administrative burden, but I think at the end of the day, the additional protection you get with the double layer is well worth that little bit of administrative burden. So with multi-state portfolios, this is where Wyoming becomes interesting. Also becomes interesting when we've got multiple partners. Okay. So let's think about a situation where my partner and I are going to start investing in real estate. Whatever comes across our desk, we're going to buy it. Property in Florida. Great. Let's form a Florida LLC. That LLC is a partnership. Take title to the property in the LLC. I have to do a partnership return for that entity. I've got to file to Form 1065, the IRS level. I would have to issue K-1s to both partners. Accountants, depending on the complexity, maybe $500, $1,000 to do that partnership return for that entity. Now we find a piece of property in Tennessee. Tennessee LLC, we don't have a holding company. Tennessee LLC, guess what? It's a partnership again. Partnership, an additional partnership return Form 1065. Additional $1,000, so on and so on. You multiply that for all of the entities you have. Now, instead, if we have a holding company, that is the partnership. That's the only entity that will do the partnership return. Everything else, the Tennessee LLC in this example, the Florida LLC, are disregarded entities for tax purposes. They're not disregarded for legal purposes. For legal purposes, they exist. We want to maintain their separate bank accounts, separate books and records, separate P&L, separate, everything associated with them. But when it comes to the IRS, all that gets consolidated up into the partnership return. So we have one partnership return to do, simplifying our tax filing obligation. So that holding company strategy where we've got a holding company in Wyoming and then subsidiaries, multiple wholly owned subsidiaries in various states, significantly reduces our tax filing and reporting obligations. So digging in a little bit further, I recommend that your Wyoming holding company is manager managed, that both of the owners there are identified as the managers of the company. They're also the members of the company, but they're the managers too. We separate those two responsibilities, ownership and management, out. It makes it's beneficial in many ways. You can appoint someone else as a manager, right? Not make them a member of the company, but if they're helping you in some way, you can give them authority to act on behalf of the company. For your subsidiaries, I also recommend that they're manager managed. Why? Because I don't want to create what I call the Russian nesting doll problem. The Russian nesting doll problem is, well, we've got a subsidiary in Florida that lists as the member the Wyoming holding company, and maybe your Wyoming holding company is owned by your revocable living trust. In that situation, we would say, well, who has authority to act on behalf of the subsidiary? It's not identified in the documents, right? There's no manager named. So we would say, well, the holding company's able to make decisions. So, okay, show me the holding company documents. Well, wait a minute. There's no human being identified in the holding company documents either because it's owned by a revocable living trust. So then we have to look at the revocable living trust documents and say, oh, okay, the trustee is John. John has the authority to sign. So the Russian nesting dolls, we have to go through 3 different sets of documents in this scenario to identify who can sign a contract for the Florida LLC. instead by naming a manager, putting the manager into the documents, making them identified or identifying them early in the process, then that individual, without revealing the entire structure, you could say, no, John has the authority to sign. Here's the documents that give him that authority. So that's one of the things I think that many people miss. They want to have them all member managed, and then at the end of the day, it's not clear who actually can sign. From an asset segregation standpoint, how much do you want to risk in a single LLC? And I think people miss this in that they think that the assets in the LLC are protected from the claims of creditors. They're not. The assets in the LLC are not protected from claims of the LLC against the LLC from its creditors. Whatever's in that LLC is fair game. They're going to sue the LLC. They're going to go after its insurance first to make sure you always have insurance. And then whatever assets are in there, those are fair game. So if you've got 5 properties with $1 million in total equity in a single LLC, and there's a slip and fall at one property, you could risk all 5 of those properties and that $1 million in equity. When you start thinking about it like that, the additional cost of a couple of $100 a year to maintain a separate LLC for each property doesn't seem like such a bad deal because you're limiting your downside. You've got asset segregation, shoebox of assets that's as small as makes reasonable sense. I talked a little bit about the scenarios where you have more than one property in an LLC. I had someone came in and they were buying properties around a lake. Each of the properties were worth about $50,000, but there was seller financing, so they only had $5,000 equity in each cabin. They created LLCs for all of them. I said, no, don't do it. I wish they had talked to me first, because now they've got this administrative burden and the additional cost associated with it. At the end of the day, they only had about $50,000 in equity in total at the start across all of these properties. They could have put it into a single LLC. You're taking a risk, yes, but when you balance that administrative cost and burden, I think that it's not as hard or fast a rule as one property per LLC. There is more out there that you need to think about. I'm going to sum it up here for you. I really think there's a tremendous benefit when it comes to real estate that you get with a Wyoming holding company and a subsidiary in the state in which the property is located. If you decide you want that double layer of protection, that you want the charging order protection, then here's how you do it right. Wyoming LLC, Close LLC, it's CLOSE. It is unique to Wyoming, and it's the best for asset protection. It really does add a tremendous amount of benefit, a whole bunch of reasons. Not going to get into it here. Wyoming Close LLC. I want you to choose manager managed for that LLC. That manager management gives you flexibility. It avoids that Russian nesting doll problem, and it will help you grow your structure. The next thing is that subsidiary company is going to be a wholly owned subsidiary. So it only has one owner. That one owner is the Wyoming holding company. I want you to do that, form that company in the state in which the property is located. You're going to make it manager managed as well. So now you've got the basic structure. What do you need? You're going to need a registered agent in Wyoming. You're going to need a registered agent in the state in which the property is located. You're going to need to do those articles of organization to form the companies in both states. You got to have an operating agreement in both states. You got to keep meeting minutes in both states. You have to have a bank account, an EIN number for both LLCs in both states, and keep up with it. This is not an afterthought. I know it's exciting to worry about the toilet breaking. No, it's not. You got to think about these things. Put it on your calendar once a month. What happened? Money went into the company. I need meeting minutes. Money came out of the company. I need meeting minutes. And I made an important decision. I need meeting minutes. Where am I in my tax filing calendar? Where am I in my payment of state fees calendar? Make sure you know all of these things and you're keeping your companies in compliance. Once you determine that this structure is going to work for you and your properties, the next step is really to learn how to scale. That's where this webinar on February 4th comes in. From one property to many, building a protected real estate portfolio is where I will show you and dig into the details. The exact legal structure that investors use to grow and protect themselves as they grow, how to maintain asset protection as you grow, and then crucial documentation most investors miss as they expand. It's not just about forming the LLC. The journey of 1,000 miles starts with one step. The journey of asset protection starts with forming the LLC, but it is an ongoing activity you have to take responsibility for. Click the link in the description to register for the webinar so that you can get the training you need to make sure you're doing it right. Don't miss out. Now that you understand how Wyoming holding companies can work for real estate portfolios, our next video is the Real Estate LLC Guide. In it, I'm going to talk about the crucial steps investors must take, how to structure your LLCs in more detail to actually protect your properties, the document mistakes that are often made, setup tips I've learned from helping thousands of clients forming LLCs. Watch our next video to learn more.